Right. A very good afternoon, ladies, colleagues, gentlemen, esteemed guests joining us from across East Africa. It's a very beautiful Thursday afternoon, and today we delve into a very interesting discussion, a discussion that has been going on for quite a while now. And as we all know, across East Africa, science is quietly, steadily reshaping what it means to create a family. The definition of family and the modus operandi of creating a family is being shaped continuously, and hope is being carried not in the womb, but in laboratories, in contracts, in cross border arrangements, and in deep personal decisions that the law has only begun to understand. Surrogacy and assisted reproductive technologies are no longer distant or theoretical. They're here with us, they are real, and they are raising questions to go to the heart of dignity, autonomy, parenthood, and justice. What does it mean to be a parent when biology, intention, and law do not align neatly? How do we protect the rights of women whose bodies make these realities possible without reducing them into instruments of transaction? And how do we, as lawyers, ensure that innovation does not outpace protection, that hope does not disturb justice? Our session this afternoon invites us into this space, a space of tension and responsibility. So, this afternoon, we'll be exploring the legal frameworks across our region, the regulatory gaps that demand urgent attention, and the ethical considerations that refuse easy answers. But more than that, we'll confront our role as advisors, as advocates, and architects of policy in shaping a future where our laws respond with both clarity and compassion. Now, this timely conversation is moderated by a lady who is widely respected in the field of human rights and reproductive health rights. She is a human rights lawyer and a senior legal advisor for Africa at the Center for Reproductive Rights. Her work has helped shape landmark jurisprudence across the region on reproductive rights, maternal health, and access to justice. She has over a decade in experience spanning strategic litigation, policy advocacy, and human rights mechanisms. She brings both intellectual rigor and grounded insights to some of the most complex questions of our time. She's not only a lawyer, but an exceptional distinction, but a voice that has consistently pushed the law to be more responsive, more humane, and more just. Ladies and gentlemen, please welcome me in joining our moderator this afternoon, Miss Prudence Mutiso. Good afternoon, Prudence, and how is Nairobi?
A very good afternoon, Gabriel. Nairobi is great. It's a cloudy Thursday afternoon today and really excited for this conversation.
Wow, we are excited too because we've been watching news bites, we've been seeing court cases coming up on surrogacy and assisted reproductive technologies. And what an exciting time to be alive and be part of this conversation.
For sure, Gabriel. And we
Yeah,
do have,
so
yes, go ahead.
so you have us here for the next 2 hours till 4
Yeah.
p.m. So we are all your guests, and yeah, we're ready to learn and take it on from here now.
Yeah, thank you, Gabriel. Thank you so much to the East Africa Law Society for hosting us and for this forum. And good afternoon, colleagues from wherever you are joining us. And thank you so much for making time to join this session today. As Gabriel has said, this is a very timely discussion because assisted reproduction continues to evolve across the continent. And infertility is a significant public health concern affecting millions of people globally, not only in sub-Saharan Africa, where the prevalence is quite high, but we've also seen the social and psychological impacts being profound. Again, despite this reality, The legal and regulatory frameworks governing assisted reproduction and surrogacy, as Gabriel has rightly pointed out, remain underdeveloped across much of the region. Much of our reproductive rights discourse focuses, rightly, on access to family planning and contraception. However, far less attention has been given to the legal, ethical, and human rights questions that arise when individuals and couples seek to build families through assisted reproduction. A related question that arises for a lot of lawyers, policymakers, and even people walking along the streets is the extent to which assisted reproduction is being accessed within Africa, and whether we are also seeing a growing trend of individuals from outside the region seeking these services within African jurisdiction. So, ladies and gentlemen, today's session seeks to contribute to that conversation. Before we begin, we deem it very useful to define some of the terms that will guide our discussion today. I'm sure you've heard of assisted reproduction. This is a broad field that encompasses all methods used to help individuals conceive. Assisted reproductive technologies, on the other hand, or ART, refer more specifically to medical procedures such as in vitro fertilization, where eggs or embryos are handled outside the body. You've also heard the term surrogacy. That is not a technology, but a legal and social arrangement in which a woman carries a pregnancy for another person or couple, often using ART. Surrogacy often takes many different forms. There is gestational surrogacy, where the surrogate has no genetic link to the child. We also have traditional surrogacy, where the surrogate's own egg is used, meaning she's genetically related to the child. We will also refer to intended parents being the individuals who intend to become the legal parents of the child, a term that is generally referred within human rights discourse. As we engage in this discussion, a number of important legal and practical questions arise. Number one, how is assisted reproduction currently regulated across different jurisdictions? How is parentage established in surrogacy arrangements? What rights and protections are afforded to surrogates and to children born through these arrangements? And then what legal and ethical challenges continue to emerge, particularly in cross-border contexts? Importantly, today's discussion will also reflect on these issues through a broader human rights and maternal health lens, particularly in contexts where legal frameworks remain fragmented or absent or in development. This includes examining how progressive standards of dignity, autonomy, and respectful care can inform the regulation of assisted reproduction and surrogacy in ways that protect and fulfill reproductive rights. And dear colleagues, we have such an excellent panel of speakers joining us from different jurisdictions, and they bring both comparative and practical perspectives to these questions. And with that, I am pleased to invite our panelists to guide us through these discussions, drawing on their respective areas of expertise and experience. And you will permit me, ladies and gentlemen, to briefly introduce our panelists so that we can know who is with us in the room. And first, I would like to introduce Professor Julia Sloth Nielsen, who is an emeritus professor, University of the Western Cape, and has been involved in children's rights reforms for more than 30 years. She was the winner of the 2024 Global Juvenile Justice Award in South Africa. She's worked to reform child justice law for more than a decade. As a member of the project team that developed the Child Justice Act, she's also worked on juvenile justice reform in many countries, including Mozambique, Kenya, Myanmar, and Sri Lanka. Professor Nielsen has published extensively on juvenile justice and related themes such as child protection and child abuse, as well as on restorative justice. In addition, she has supervised many PhDs, including in fields related to juvenile justice, as well as numerous LLM theses. She continues to work collaboratively at the international level as well as within domestic legal systems. So feel very welcome, Professor Julius Nielsen. Next, I would wish to introduce Dr. Tom Mulisa. Dr. Tom is a lecturer of constitutional law, human rights, and governance at the Law School of the University of Rwanda. He holds from the Center for Human Rights of the University of Pretoria and a PhD in comparative constitutional law from Uppsala University in Sweden. Tom is also an Oxford constitutional law researcher and an external examiner with the Center for Human Rights. Tom is also the founder and executive director of the Great Lakes Initiative for Human Rights and Development, GLEAD, with an interest in public interest litigation, SRHR advocacy, and human rights monitoring. He's also a member of the Credentials Committee of ECOSOC under the African Union, and Tom has published widely in human rights, women and health, governance, and constitutional law. Please join me in welcoming Dr. Tom Molisa today. Next, I'd wish to introduce Ms. Gemma Daly. Gemma is a lawyer with over 20 years and is a partner in the adoption, surrogacy, and international child care department at Goodman Ray Solicitors. Gemma specializes in and has extensive experience of complex, I beg your pardon, of complex international adoption and surrogacy cases, as well as being highly regarded for her expertise and growing practices in cases involving children who are conceived by way of artificial insemination. Gemma has been at Goodman Ray since 2001 and was made a partner in 2009. Gemma is listed in the Legal 500 for her in-depth knowledge of international adoption and surrogacy cases, and she joins us all the way from London. Welcome, Gemma. Next, I would wish to introduce Ms. Rose Wachikona. Rose is a feminist lawyer with over 12 years experience working in public interest litigation and women's rights. Currently, Rose serves as the Deputy Executive Director of the Women's Pro Bono Initiative of Uganda, where she works to ensure that not only progressive laws and policies supporting of women's rights are passed, but they are also implemented. Rose holds an LLB from Makerere University, a postgraduate diploma in legal practice from the Law Development Center, and an LLM in sexual and reproductive rights in Africa from the Center for Human Rights at the University of Pretoria. Please join me in welcoming Rose. Last but not least, we have Ms. Wanjiru Kamanda. Ms. Kamanda is an advocate of the High Court of Kenya, and she holds a Master of Laws degree from the University of Nairobi. She has over 15 years post-admission experience in human rights, gender, sexual, and reproductive health and rights. She's currently the Senior Advocacy Advisor for Africa at the Center for Reproductive Rights. She previously served as a Deputy Executive Director and Head of Programs at the Federation of Women Lawyers, FIDA, Kenya. And she's also worked with the International Development Law Organization as a legal consultant, seconded to the judiciary in Kenya. She is a member of the Law Society of Kenya. Ladies and gentlemen, please give a warm welcome to Ms. Wanjiru Kamanda. And I don't know whether Professor Nielsen has joined us. Professor, if you've joined us, please just indicate. All right. So as we wait for Professor Julia to join us, I would like to hand the discussion to Dr. Tom Mulisa. And Tom, I would wish for you to speak to us about regulating assisted reproduction in Rwanda, the legal, and the implementation under the health services law. Particularly, Tom, we would wish to understand how AR and surrogacy is regulated in Rwanda under the Health Services Law, and whether the current framework is promising and how these issues were addressed previously before the law came into place. We'd also wish to hear from you, Tom, what forms of surrogacy are permissible, including whether the framework contemplates gestational or traditional surrogacy, and how legal parentage is acquired in surrogacy arrangements. Over to you, Tom. You have 15 minutes.
Yes, thank you very much. And thank you for inviting me to this nice information sharing session. I hope you can hear me.
Loud and clear, Tom. Yes, you're good.
Thank you very much. Yeah. I think I will begin with the previous situation. Before 2024, we did not have any legal and policy framework with regard to assisted reproductive technology in Rwanda before 2024. That is why in 2020, that's when we had the first case. So we had the families and the selected surrogate who approached the court to seek that one family partakes a pregnancy on behalf of the other. So our primary court, which could be considered as a magistrate court, the lowest court, told them that we don't have legislation in Rwanda. So for that reason, that's an issue that the court cannot entertain. That is 2020 in June. Then in September, they appealed to an appellate court, which could be like a provincial court, just below the High Court. And that provincial court thought it could entertain the case, even though we didn't have a single legislation to that, because our family law did not provide for assisted reproduction. So that court invited our law school, that's the law school of the University of Rwanda, as an amicus to that case. I think we knew very well that there is no legislation, but we basically looked at the comparative practice elsewhere, and we provided our amicus brief, amicus position as a school of law. And the court accepted that it could be possible, since it happens elsewhere, it could be possible that one family could partake, and this could be possible in Rwanda, even though there is no legislation. So that was the first case we had in 2020 in September, despite not having legislation in place. Why I mention about that judgment is that the judgment mentioned that upon delivery, the child should be registered to the biological mothers upon delivery immediately. Because why I mentioned the decision of the court is that some of the issues that were mentioned in that case were not addressed in the subsequent law that came out in 2025. So in 2024, we had a revised family law. The family law of Rwanda was revised in 2024. And the family law had a provision, Article 279, that stated that the production between spouses occurs naturally. That's one point. Or by means of assisted reproductive technologies. That's 2024, 4 years after, including surrogacy. Assisted reproduction between a married man, I need to underline the word married, a married man and a woman may occur between them and a third party through a written contract in accordance with the law. That is 2024. Even though we had that provision in 2024, we didn't have any law and guidelines to assist assisted reproduction. So that is why in 2025, just last year, we had a law now in place. I needed to go through that sequence. We had a law in place. But still, as I will mention, I'm going to just talk about the key things in that law. Article 23 talks about persons eligible. It says that the persons eligible are only spouses. So those are people who are legally married, not cohabitation, not informal marriages. only spouses, or an individual who has been diagnosed by a health professional and unable to reproduce. That should be underlined because I'll talk about it at the end with regard to some human rights implications. Unable to reproduce naturally and permitted to reproduce through that. So it means that this is a married couple and the doctors have proven that you are unable to reproduce naturally. So it means that for those who can produce naturally but need to do assisted reproduction, they are not allowed. You must be married legally. So marriage is a condition, which we shall talk about the implications. If someone doesn't need to get married and you just need to have a child, this law does not protect you. So, but again, the law says that a ministerial order will come out, which will establish a committee that will supervise reproductive technology services. This ministerial order is not out. Perhaps some questions that you will be asking me, I may be referring them to the committee that will be put in place in future. So the law talks about the qualified healthcare professionals. I would like to talk about that in relation to access, because there should be an endocrinology specialist, or obstetrician gynecologist with accredited training. So not every gynecologist can do that, and not every endocrinologist can do that. You must first prove that you have training in reproductive techniques. That's a condition. And then the law continues. I won't talk about the surrogate mother. This one should be between 21 and 40, and to have previously conceived and carried a pregnancy to a term without complications. So if you're a surrogate mother, you need to prove that you have previously conceived. I think this letter would come from the hospital gynecologist. And you must prove that you must have had pregnancy without complications. This is important to be spoken about. And then to have undergone medical examination by a healthcare professional, which confirms that you can give birth without complications. I don't know if one can really know before the term that you can give birth without complications. That is a condition. You must prove that, because you may deliver one child without a complication and have a complication on the other one. And again here, the law gives us a note that a ministerial order will specify the maximum allowed number of pregnancies for a surrogate mother. So it means that you can be a surrogate mother for a certain family, but then the law will specify how many times, 2, 3, 4. That law will come out with the whole, with how many times a surrogate mother can do that. And then there are some obligations of the surrogate mother, which seems to be very hard. Regularly update the commissioning parent on the status, to hand over the child to the commissioning parent, and all that. Then there is also obligations of the commissioning parent to find the surrogate on your own, to cover the cost of healthcare services for the potential effects on the surrogate mother. Cover the cost of healthcare services for the potential effects of the surrogate mother, and to accept the outcome. And then I wouldn't go much into the prohibitions, modifying genes, selecting sex, and all of that. But I would like to talk about what I think is very key within this law, of 2025, just as I end here. First of all, surrogacy is available only to couples with the medically confirmed infertility. That one should be noted. And it means that ART is treated as a medical intervention, not as a lifestyle option. Medical intervention, not a lifestyle. It's not a choice. So surrogacy is not by choice. But by this law, surrogacy is not by choice, but should be a medical recommended treatment or intervention. Then this should take place, the contract should take place before a notary who is a lawyer, the contract. And we, up to today, the Bar Association and the notaries have not got training with regard to surrogacy. I'll talk about that in terms of challenges. And another important thing, that means before the contract, so it means both of them need a lawyer. Even the surrogate mother needs a lawyer, and the two parties. So restriction, which is the honor to marriage, to the married couples, is quite important. And we're waiting for the ministry to appoint a committee. It's not yet in place to monitor compliance. So even before the committee, surrogacy is happening. We have 2-3 clinics here with trained gynecologists who are doing the work. I spoke to them, I think, last week. It's happening today. They have not yet recorded some of the issues, but we are still waiting for that committee, and we are yet to see what the committee is able to do. So that is in brief the general scope of the law, and I would be very happy to come in for any other specific question. Thank you.
Wow, thank you so much, Tom. I feel like I'm in, a law school. That was really, really insightful in terms of how, the law on surrogacy has developed in Rwanda and where we are at this particular moment. One of the things, Tom, I would be keen to understand, and I'm sure the audience is interested in understanding, is whether this particular law anticipates cross-border, surrogacy arrangements. And I know you spoke a little bit about the gaps. Do you see any, potential for improvement in this particular law, as it were, just briefly?
Yes, I think that there would be improvement, because the law does not mention about the nationalities of those seeking the ART technology. I think the fact that before we got gynecologists doing the work, most of our people have been traveling to Kenyan clinics for the services. So the law does not specify. It talks about a person of this age. So it basically and it is the intending family that chooses the surrogate mother. So they don't talk about issues of nationality. That is, to me, meaning that as long as the two parties have agreed and contracted, then this contract can always proceed as long as it follows the law. I'm not very sure whether I had on the other question.
Yeah, it was about the promises or the gaps around this law. Is there an opportunity to
Yes,
address some of these gaps?
yes, I'm seeing the opportunity, because it's quite good that the not more than 3 clinics, by the way, in Kigali. I've not had any other outside the capital that are doing this type of services. And I'm quite happy that the gynecologists I found there, who have got trainings in India, have done some practice in Kenya, I've quite understood that with this ministerial order,
Yeah.
with this ministerial order that will come to help this law, this is the only space that we have today to address some of the challenges that we are seeing, which some of the challenges in terms of supervision, because the nature of the contract and contents of the contract are not also mentioned. So some lawyers we met were not very sure on what terms people should agree in terms of the contract, whether what is not mentioned in the law as a prohibition could be agreed as the nature and the terms of the contract. And we have also no rules for Rwandans seeking ART abroad or foreigners seeking surrogacy in Rwanda. But one was talking about the risk of statelessness for children born through such arrangements, considering some of the issues we have. Some people thought we could look into that. And then lack of an order, that ministerial order, I think, will be covering in that, because it should be giving us more of the relations between the commissioning parent and the surrogate mother. So how, in case of we don't have any dispute resolution framework or caveat within the law of what more is, except saying the surrogate mother should have this and the commissioning parent should have this. So
Yeah.
we need to go beyond. And I think with this ministerial order, which is yet to come, I call it, I think this is an open opportunity for us now to work around that ministerial order, to fill the gaps, and what has not been mentioned within this law. So I think the ministerial order would be quite also important. Article 100 bans anonymous gametes, but no framework for donor conceived children to access genetic information upon childhood, as provided in the Convention on Rights of the Child. So I think there is a window. There is a window with the ministerial order to come, as we have done before in other legislations, that the ministerial order could solve some of the issues that we have today. Thank you.
Yeah, thank you so much, Tom. Ladies and gentlemen, that's Dr. Tom Mulisa, all the way from the University Law School of Rwanda, having spoken to us about AR and surrogacy regulation in Rwanda, marriage as a condition to access AR or surrogacy, and ART being used as a medical intervention and not a lifestyle choice. If you have any questions, please, for Tom, have them in the chat, and any comment as well, and we'll definitely come back to you during the Q&A session. So thank you so much, Dr. Tom Mulisa, for that great intervention. Next on, we'd like to move to Uganda. And at any time, Gabriel, I would like to request, once Professor Julia is in the room, please do let me know. But at this moment, I'd like us to invite Ms. Rose Wachikona. And Rose, all the way from Kampala, Uganda, will speak to us about the legal gaps around, as he said, reproduction and surrogacy, the emerging trends, and some of the responses, including reflections on the successes, challenges, and practical pitfalls of the current AR bill in Uganda. And Rose, I would wish you to also look at how some of these surrogacy arrangements are operating in practice, including key risks for women, children, and intended parents, and of course, speak around some of the challenges affecting surrogacy and AR in Uganda, and human rights-based recommendations to address some of the existing gaps. You have 15 minutes. Rose, over to you.
Thank you so much, Prudence, for that wonderful introduction. I'll do my best. When I heard that Dr. Tom was an external examiner for the Center for Human Rights, I wondered, because my dissertation was on assisted reproductive technologies. So I was like,
I did not read your thesis. It's my colleague who read.
Wow.
I said it gave me good marks. I was happy. So, yeah. So in Uganda, we have no existing regulation for assisted reproductive technologies. Efforts are being made to have a law put in place, but because of the bureaucracies that we have in our lawmaking systems, the law has been pending up to now. It was tabled in 2023. It mirrors the law, the Rwanda law and the Kenyan law. So they picked bits and pieces of what they have in those legislations and are trying to make sure that it is passed. So we are expecting the Ministry of Health to actually pass a legislation on at any time soon. So I will start from there to say that we have no regulation. So how is it done right now? People who are carrying out assisted reproductive technology are largely relying on contractual law. So that is for the commissioning parent and the surrogate, or for the donor, they will enter into a contract. So it's subject a lot to contractual liberty and what the parties agreed to. So of course, when you look at it on the surface, it seems like, oh, maybe this is okay. But here we are talking about very vulnerable women who often offer themselves up as either donors or as surrogates. Most of them are very poor. Most of them are semi-illiterate, and therefore their negotiating capacity is extremely low. Many of them don't understand the contracts that are placed before them or even what they mean. And therefore, you'll find that someone enters a contract that is very damaging to them and how they are able to exercise this role that has been thrust on them. Majority of these women will enter into the surrogate contracts because they want money. They will not do it because they are out of the goodwill of their heart or they want to help someone have a child. No, that's not how it happens. They do it because they want money. We have very high poverty rates in our country. So many people will look at this as an opportunity to pull themselves out of poverty and maybe improve the economic status of their families. So you'll find that the payment for a surrogate in Uganda averages about 2,000 US dollars, which is about 7.5 million Uganda shillings. May seem little, but for many of these women, it's really a lot. A cycle for maybe IVF, if you need it, will average about 7,500 shillings. So the gap between what goes to the surrogate and what ends up with the hospital or the clinic is quite huge. It's barely a quarter of what they end up with in terms of payments. So how it happens is that you will be onboarded as a surrogate. You will enter into this contract that you probably don't understand or haven't thoroughly read. You probably want to be given a copy. And then as part of the contractual uh, clauses that are put within is that you're going to be kept in a dorm for the duration of the pregnancy. So you're almost locked up, for lack of a better word, you're locked up for those 9 months. And they will determine what you eat, how you sleep, what vitamins to take. All medical decisions are made on your behalf, and you cannot say anything about it. And actually, some of the contracts I've read, you waive all rights to medical decision making. They will mandate you to have the baby by way of C-section, and because they say that it is safer, and the doctor will then have more control over the outcome of the birth than if you did a vaginal birth. So there are a lot of things within those contracts that are very much cruel and inhuman for the women who end up entering in them, and they rip them of their medical autonomy. It rips them of their ability to decide concerning their own bodies, and very few understand what they are actually entering into. Some of the cases that we have received within our office, because we do a bit of litigation around sexual reproductive health and rights in our office, women who have ended up having their uteruses removed without consent, maybe because they ran into some trouble while they were conducting the birth, and then they just make this arbitrary decision. Women who are locked up for 9 months are not allowed to contact their people because they fear that if they don't keep them within a locked space, they are going to run away with the babies. So there is a lot of prioritization of the rights of the commissioning parent rather than for the surrogate or for the donor who enters into some of these arrangements. So when you look at it, there is a power imbalance. And for us feminists, we are always trying to look at where the power imbalance is. And the expectation of the law is to try and even this power imbalance that we constantly see. So our expectation was that the proposed human assisted reproductive technologies bill is going to balance some of these power gaps that are existing within the dynamics and the relationships that we have. So when you look at how then the parental rights are exercised, is that when you give birth, they will list the commissioning parent on the birth certificate. Because for us, in our law currently, when you look at our Children's Act, the person who births the child is the mother of the child automatically. So they will just list the past, even if they didn't birth, they will list them. Otherwise, you would have to go through the entire adoption process, which takes about 3 years to conclude. So that is how they are jumping that hurdle. And then you just come out of the hospital as a commissioning parent and say, oh, I produced this child. Whether you got pregnant or not really is none of their concern. And not very many people will look or inquire into whether or not the person who birthed is the one who is on the actual certificate. So for the proposed law that is being put on ground, they're trying to clear this by awarding parental rights to the commissioning parent automatically, which is as it should be when you're discussing assisted reproductive technology, because again, there is no genetic link if you're looking at gestational surrogacy. But when you're looking at the traditional surrogacy, then the surrogate is also donating and an ovum. So they have a genetic link, which is not dealt with within the proposed law. The proposed law is also very classed. It doesn't address the exorbitant costs of assisted reproductive technologies. As I told you, a cycle of IVF will cost you about 7,500 to 8,000 US dollars. And that is counting on the low side. Many Ugandans cannot afford this. So the people who are actually taking advantage of these services are international, because compared to other countries, it's quite low. If you're to do this in the US or in Europe, it will be a bit expensive. And very many Eastern European countries have actually prohibited the use of surrogacy. So they will come to Africa, they will come to India in order to do some of these. And for them, 7,500 is just, it's okay, it's a lot, but it's something, it's money that they can actually part with. So these services are a lot for the very rich Ugandans, not so much for the poor Ugandans, and also for international. Also, there is an emphasis on heterosexuality and married couples. Again, as Dr. Tom said, even our proposed legislation is insistent on it being for married couples and not for single people. They are out of the loop. For same-sex couples, they are out of the loop. So they are closed out of people who can access IVF. And yet the problem is that we have about 30% of couples in Uganda who are dealing with infertility issues because of our high rates of due to secondary and primary infertility. Primary infertility is not so high, but the secondary one is quite high because of the criminalization of things like abortion, which force people to go into unsafe abortions, which will impact their fertility, their sexuality education, which is quite low. So secondary infertility is quite high in the country, and therefore many people would love to access these services. And yet we know that women in Uganda are heavily stigmatized if they don't have children. If you are there and you say, oh, I'm living child free, everyone is like, what is wrong with you? Eh? Please produce and add to your clan so that you get the blessing. There is a heavy stigmatization of women who do not have children. So many of us will do whatever it takes in order to be able to have a child. And so there is a need to actually have these children. But if they don't address the issue of money and being able to make these services economically accessible for people, then it's going to be very difficult. The other thing maybe I wanted to note, and I know my time is fast spent, is the issue around informed consent. Again, I had already talked about the fact that many of the people who enter these contracts are semi-illiterate, not completely illiterate, but they can't really understand a lot of the terminologies that go into these contracts. So they will sign because they look at the figure and it looks good, but then they don't understand the full thrust of the risks that are associated with this. And also the low payments I have talked about there. So that is what I can say for now. I will put in the chat some of the analysis that we have made concerning the bill, but also some of the studies that have been made concerning art in Uganda that maybe Dr. Zahara Nampel has written extensively about assisted reproductive technologies from the Makerere School of Law. So I'll also drop some of that matter so that you can be able to read even more. Thank you, and back to you, Prudence.
Well, thank you so much, Rose, for that great intervention and the insights as well. And, just hearing from you, the power gaps, that continue to exist in Uganda, it's very evident, from your presentation and submission that surrogate mothers in Uganda really don't have much of rights, given the power dynamics and the the gaps that continue to exist. Because I was going to ask you, what are the rights of the surrogates? But just listening to that, you can just continue to see how their dignity continues to be violated, and they're subject to cruel, inhumane, and degrading treatment. But before I let you go, Rose, I was wondering, what have the courts, stated on this issue? Of the courts have had an opportunity to speak about, the gaps around AR and surrogacy. I know from your submission, you've indicated that the courts have ordered that, parental rights are automatic for the intended parents. But what have the courts said on this particular issue?
Actually, our courts haven't pronounced themselves. What I have said is that the proposed law is trying to make the parental rights automatic. But currently, as it stands, the parental rights lie with the person who backs the child. So that would be the surrogate. What they do is that they will list the commissioning parent on the birth certificate. And once you're listed on the birth certificate, then you automatically become the parent. Our registration bureau will not inquire so much into whether or not you're the one who, as long as you're the hospital will notify that these are the parents, they will list those on the, so that is how they are, it's illegal, but that's how they're overcoming that hurdle. Our courts, I know there are suits that have been made on some clinics, but they have been very intentional in making sure that there is no judgment that comes out. So they will settle these matters out of court as soon as they come in, enter consent. And so in terms of jurisprudence, I haven't come across any. I'm not sure if anyone knows any, but as far as I know, we haven't really had any court come out and concretely discuss the issue of the rights of surrogates and commissioning parents. No one has, but suits have been brought. It's just that they will rush to. And of course, when you're already dealing with people who are vulnerable economically, any sum of money to settle a matter out of court will just seem like a win for them. So the bigger issues maybe may not be as consequential as you maybe who wants to take it forward would like it to be. So that's where we are at right now. Our only hope is for maybe this 12th parliament that is coming in to address its minds to the bill and actually pass it, at least with a few amendments, in order to improve the protection. We had made recommendations to the Health Committee of Parliament to at least look at the Kenyan legislation, because we thought it was a bit more forward-looking in terms of the protections it extended, especially towards the surrogate, and maybe adopt some of those things that are therein to do a better job. But they told us they'll do a benchmarking visit. I don't know, they haven't yet. So we'll see how it goes.
All right. Thank you, Rose, for that intervention. And thank you so much for colleagues as well for continuing to pay attention. If there are any questions or comments, please post them in the chat and we'll address them during the Q&A session, even as we move along the discussion. So, colleagues, at this point, allow me to jump all the way to London and invite Ms. Gemma Daly to make her submissions around surrogacy and assisted reproduction in the UK, the experiences that she's had around cross-border practice, because I know she's also had practices with lawyers across Africa, and some of the emerging legal and ethical challenges that she's experienced. And of course, Gemma will share with us some of the lessons as well from the United Kingdom around the issue of today. Gemma, you have 15 minutes. Over to you.
Thank you, Prudence, and good afternoon, everyone from London. Very sunny here today. I hope it's not blinding you, sort of, on my background. Thank you so much for inviting me to be a part of this panel discussion today, because the topic of surrogacy is always a really difficult one. We have such different perspectives on the issues that are raised by surrogacy. Internationally, surrogacy regulation presents a patchwork of different approaches. Many jurisdictions are now grappling with what to do with the changes in surrogacy trends, the emerging hotspots, and as we've heard from Rose and Tom already today, the development of new regulation and laws around surrogacy arrangements. So it's actually really important that we find spaces like this to think about these unique challenges And in particular, from my perspective, I'm going to talk to you about my experience of cross-border surrogacy, which, as we all know, is driven by supply and demand. And that's why we're all seeing this boom in the global surrogacy industry. So just looking at the UK for a moment, it has always been lawful in the UK to enter into a surrogacy arrangement. But to understand how and why English surrogacy has developed in the way that it has, I'm first going to talk to you about how surrogacy arrangements here are regulated before looking at some of the problems and looking at the reasons why most of our intended parents actually don't commission surrogacy arrangements here, but look abroad when they want to start a family. So surrogacy arrangements in the UK are regulated by legislation. The key legislation is the Surrogacy Arrangements Act 1985, the Human Fertilisation and Embryology Acts 1990 and 2008. But the 2008 Act really relates only to the assignment of legal parentage for children who are born by way of ART, including surrogacy. So the first thing I think is really important to note, and different from the discussions that we've already heard today, is that our regulatory legislation is more than 40 years old. So although it would have reflected societal beliefs about surrogacy at the time, the practice has changed so much and our legislation is quite frankly out of date. Those of our High Court judges who consider these cases on a day-to-day basis have described our legislation and regulation as not fit for purpose. And I'm going to talk you through some of the reasons why that may be. It doesn't reflect what's currently happening. It doesn't reflect the current attitudes towards surrogacy arrangements. And in particular, it doesn't reflect the modern reality of surrogacy, which by that I mean the global industry of surrogacy, the moving across borders, leaving our courts to plug those gaps. And so there's a real risk for us that our current legislative framework, without the courts plugging the gaps, does not adequately protect the rights of children, prospective parents, or surrogates who are involved in the practice. So one of the fundamental principles of our current legislation is the desire to prohibit commercial surrogacy arrangements. So we only allow altruistic arrangements in the UK. And with this comes a criminal offence of advertising if a person is looking for a surrogate, a person is willing to act as a surrogate, or if there's a third party who is willing to facilitate the making of a surrogacy arrangement. So just to note, for us, this includes solicitors who charge a fee for formalising a surrogacy arrangement. In the UK, we're prohibited from initiating or taking part in any negotiations with a view to making a surrogacy arrangement on a commercial basis. So although when the legislation came into force 40 years ago, that part of the legislation was primarily intended to not only stop surrogate mothers from offering their services for commercial gain, but to prohibit commercial surrogacy agencies profiting, what it actually means today is that surrogates and intended parents in the UK can't access legal support about the arrangements prior to conception. The other fundamental principle of the current legislation for us is here in the UK, surrogacy arrangements are not enforceable. They are not commercial contractual arrangements that can be enforced if there's a breach of the agreement. So any dispute about whether the surrogate will hand the child over or whether the intended parents will collect the child becomes a welfare issue to be decided by a family court judge looking at what is best for the child, welfare being the court's paramount consideration. So the fact that there is a surrogacy arrangement becomes a part of the factual matrix, but it's not determinative. And so for many UK intended parents, this uncertainty for them is just too much. So although we have these strict prohibitions on commercial contractual arrangements in the UK, and although they might appear on the face of it to meet the moral and the ethical dilemmas regarding surrogacy arrangements in the UK that were identified by Parliament all those years ago, with the changes in surrogacy practices over the last 40 years, does this really now mean that the very important protections for women are actually resulting in the potential for exploitation of even more vulnerable women in other countries? And you'll see, because of the restrictions that we have in our arrangements in the UK, what this means for us and for our UK intended parents is that on the ground, there is a significant shortage of women who are prepared to act as a surrogate. So UK intended parents who want to commission a surrogacy domestically may wait 2 or 3 years to be matched with a surrogate through a not-for-profit agency. So this fact, coupled with the ease by which one can cross national borders, means that many couples are sidestepping our domestic restrictions And because the reality is that commercial surrogacy is being practiced outside of England and Wales, our UK intended parents will go to those commercial destinations where there is, from the UK perspective, no regulation. And in many cases, couples will go to a foreign jurisdiction to commission a surrogacy with no legal advice about the consequences, which is essentially supporting and allowing this practice that UK legislation has expressly disallowed. So what we see in the context of English surrogacy is a year-on-year increase of individuals and couples going abroad to undertake surrogacy arrangements, resulting increasingly in a loss of the state's ability to ensure that exploitation, commodification, or abuse is not occurring in those arrangements. So if we look at the international arrangements, for UK parents, the very first time that there will be any scrutiny of those arrangements is when the child is already born and in the UK with their intended parents, and they are in front of an English court asking to be recognised as the child's legal parents. So I have to ask myself, as all of us who practice in England and Wales do, are we now in a position where we're looking to the courts for regulation, which is effectively achieved through the granting or the refusal of the parental order, which, for those of you who don't know, is the order which transfers parenthood from the surrogate mother and her husband, if she is married, to the intended parents. And this is a job that's just not being done by our statutory framework. What we don't know, very worryingly, because there are no statistics, is how many intended parents even come to the court for a parental order following an international surrogacy arrangement once their child has been entered to and remain in the UK, because often they're coming in, as long as they're allowed entry, and we'll talk about that in a moment, with a birth certificate that names them as parents. And that's the document that they wave in front of the school and the medical authorities and any authorities when they need to make decisions about a child. And so lots of intended parents either don't know that they need to apply for a parental order, or they don't see the value of it and don't see the need for it. So there's a huge gap there of international surrogacy arrangements which are not even being regulated by our courts. The reason why you need to go to the court in England and Wales for a parental order is because, like many jurisdictions, the UK treats the woman who gives birth to the child as the legal mother always. And if she is married, then her husband is the legal father of the child. So even if the child is born in your country, and in your country your laws say that the intended parents will be the legal parents, this is just not recognised in the UK. Now, who the child's legal parents will be is relevant in the immediate period after birth for UK nationality and immigration rules. Because if it cannot be established that the child is British because their British genetic parents are not their legal parents, that child will have great difficulty entering and living in the UK with their intended parents. And it can, and it does result in lengthy periods of time in which the child will have to stay in the country of birth, pending the issue of a passport or travel documentation to enable them to travel and enter to the UK. And I've been involved in cases where this has taken years to resolve, up to 4 years in one case, to resolve these issues. And in the meantime, the child is stateless, living in the country of birth, and the attended parents are having to make elaborate arrangements for the care of their child in a country that they don't live in, and sometimes don't have their own permission to stay in that country beyond a visiting visa. Now, when you come to make an application for a parental order, the criteria for the making of the parental order is set out in the HFEA, the Human Fertilisation and Embryology Act 2008. I'm not going to take you through all of that criteria, but relevant to international arrangements, and in particular relevant to those children born in some African jurisdictions, are the following criteria. So to get a parental order in the UK, the gametes of at least one of the applicants must have been used to bring about the creation of the child. The UK does not allow for parental orders to be made in cases where the child was conceived using donor sperm and a donor egg, what we call double donation. And there have been a number of cases over the last few months coming to our High Court involving intended parents who are in their 70s commissioning surrogacies, for example, in Nigeria and in Ghana, in some of those cases, they are double donation cases, and those parents come to court and they cannot get their orders. The other criteria that's relevant to international surrogacies is at the time of the making of the application and at the time of the making of the parental order, the child's home must be with the applicants, who must be domiciled in the UK. And we've talked about a moment ago why that is problematic for children who can't enter and are stuck for years and years outside in other countries of birth. The court also must be satisfied that a surrogate consents to the making of a parental order. And this consent must have been given freely and with full understanding more than 6 weeks after the birth of the child. Now, this is something that we are having increasing difficulties with, particularly in respect of those surrogacies in African countries that insist in confidentiality arrangements between the surrogate and the intended parents. Because in this situation, we have UK intended parents who don't know the identity of the surrogacy. They don't know their name. They don't know how to get hold of them. They have never met them. They have never spoken to them, and they have no way of contacting them. And this is relevant to the issue of informed consent, which is an absolute red line for our courts. If there is not informed consent, a parental order will not be made. So more often, as we see an increase in surrogacies coming from African jurisdictions, we're seeing paperwork from the clinics and the agencies coming in English. There is no way to understand whether the surrogate speaks English. There's no way to understand whether the documents such as the surrogacy agreement or the consent forms have been translated to her. And there is a risk, a huge risk, that these consents will not be accepted by the court. Now, I'm just going to very quickly give you an example of the kind of issues I'm talking about. Earlier this week, I met a couple for the very first time who commissioned a surrogacy in Ghana, and their surrogate was pregnant. She was giving birth in June. And this was the first time they sought legal advice anywhere. No legal advice in Ghana, no legal advice in the UK. No authorities in England had had any involvement in this arrangement whatsoever. No regulation, no oversight at all. My female client is in her late 40s, so she's not able to use her own egg. Her husband is in his 70s. Both were born and brought up in Ghana, but were living and working in the UK and had been for many years. And when they decided to have a child together, they needed to go for a surrogacy arrangement. So they contacted an agency in Ghana. They wanted to do their due diligence. They wanted to make sure it was a proper agency that they could rely on, and they went to visit the clinic in person. Surrogate was selected for them, but she is anonymous. The husband's sperm was tested, found to be unsuitable, so they proceeded with a double donation arrangement. They don't know whether the egg used was a surrogate's egg or a donor egg. That doesn't appear to have been adequately explained to them by their clinic or their agency. They think it's a donor, but they're not sure. The donation is completely anonymous. And obviously they don't have any contact with the surrogate to understand her experience of the surrogacy or to verify her consent. What we do know is that the surrogacy agreement records that she has waived any rights to decide whether to abort the fetus, save if there's a risk to her health, which is not uncommon. And the contract also states that she will be paid approximately £3,000, that's English pounds, for the surrogacy. And again, the contract is in English and they assume that she understands it. They don't know. What they have no idea until they saw me this week is that they are not legal parents of this child. They knew that they would be legal parents under Ghanaian law, but they didn't know that that would not be recognised, and they cannot bring their child to England. In order to be able to bring their child to England, to live here with them, they are going to have to undertake a minimum of 18 months of procedures and applications through the immigration courts to try to get citizenship or a right to remain in this jurisdiction for that child. But they also didn't know they couldn't apply for a parental order once they get here because of the double donation. This case example shows clearly the need for more control and regulation for international arrangements. And sadly, this is someone who came through my door this week, but these are people who come through my door every week. And it's not important just for the requirements of the parental order. I want to make that really clear, but it's also relevant to the medical and the ethical issues surrounding the fertilisation and the pregnancy of the surrogate. Because when UK judges are currently considering parental orders for children who are born by way of international surrogacy, they're not given the chance to consider or to regulate whether the surrogacy has involved medical procedures that are medically and psychologically damaging for the surrogate, nor do they have the ability to evaluate the quality and the safety standards of the procedures, or whether there are any unprofessional or unethical practices. Courts can't control whether there have been adequate counselling or social assistance for the surrogate mother, or whether there has been any independent advice, because they are looking at, essentially, a fait accompli. The child is there in front of the judge, needing to have legal parents, and we have a welfare-based jurisdiction. So what is needed in the future? How are we going to regulate surrogacy and ART in a way that's ethical, inclusive, and responsive to the modern realities? I'm conscious, Prudence, that I'm close to my time, but I just want to say that our Law Commission has done a comprehensive review of surrogacy regulation and law in the UK and has made recommendations, but only for domestic surrogacies, which includes, as Rose has explained, is a proposal for Uganda, that intended parents will have parental responsibility from birth. However, an overhaul of our surrogacy legislation is not going to happen in the UK for the foreseeable future. It is on the back burner as far as our governments are concerned. And so what we're left with is, following a number of problematic recent cases and to try and plug some of these gaps, our High Court has set out very recently guidance that all parents must follow before entering a surrogacy arrangement overseas, to ensure that the surrogacy arrangement that they are planning is lawful, ethical, and in their child's best interests, with a very, very clear warning from our courts that those who deliberately do not follow this advice may later be refused a parental order. That's the best we can do at the moment. I won't go through this whole list of 21 recommendations because we don't have time, but I'm very happy to distribute it, actually, if people consider that this would be helpful. But in summary, the list puts an emphasis on early legal advice in each relevant jurisdiction, understanding the practical steps that are needed to get the child home, assessing the role of the agencies critically, and ensuring that the surrogate is being adequately informed and supported, and she understands what the arrangements will be. Proper records are kept, taking steps to ensure the welfare of the child, and that is with an eye on identity. Because lots of these surrogacies coming from other countries come with anonymous donations and anonymous surrogates. Anyway, I think it's fantastic that we've got this opportunity today to talk about these issues, to talk together about what's working and what's not working, because the only way that we're all going to get this right from a moral and ethical point of view is to learn from each other, to listen to each other. Surrogacy is not going away. We've got to all create legislation that reflects the realities of these modern arrangements. Thank you.
Wow, thank you so much, Gemma, for that great insight. I mean, just listening to you, I was thinking about the children who are, deemed stateless and are sort of legal orphans, quote unquote, up until, the courts decide their fate. But one of the things that has also come out from your submission is the length to which, the courts in the UK will go to protect the surrogate mothers, and especially around, the issue of informed consent. And I'll come back to you later. And one of the things, perhaps you can also speak to us a little bit during the Q&A session, is some of the rights that the surrogate mothers are afforded in the UK, especially around, autonomy, bodily autonomy, and the right to make, medical decisions about their bodies. But thank you so much, Gemma. Listening to you, it's very clear again how parentage, is transferred in the United Kingdom, and there's an opportunity to learn, whether it's from Rwanda, Uganda as well. So thank you for that intervention. And I can see some questions and comments in the chat as well, and we'll get to that during the Q&A session. And I'll just ask my panelists to also be looking at the Q&A and see whether they can respond to some of the questions as well. At this point, colleagues, we are still waiting for Professor Julia. I'm informed that some colleagues are trying to help her join. And so once she's able to join, then we'll give her an opportunity to make her intervention. But permit me at this point to invite Ms. Wanjiru Kamanda to give her submissions around assisted reproduction, looking at the issue of maternal health. Wanjiru, we've listened to Tom, we've listened to Miss Gemma, we've listened to Rose as well. And from the Uganda perspective, you can see how the surrogates really have their rights violated day in, day out. You can see from the UK the length to which the court is going to protect these surrogate mothers. And Wanjiru will be making a presentation around some of the work the Center for Reproductive Rights has done in having progressive maternal health standards and how the same can be applied in protection of surrogate mothers. And Wanjiru will also have an opportunity to reflect on the current assisted reproductive technologies bill in Kenya, the successes, the challenges, and some of the practical pitfalls as well. Wanjiru, you have the floor and 15 minutes. Over to you.
Thank you, Prudence, and thank you, colleagues who've already spoken on this and made some reference actually to the Kenyan bill in their presentation. So I'll speak briefly and give a bit of context. So like Rwanda and Uganda, Kenya does not currently have a specific law that regulates surrogacy. However, Kenyan courts have dealt with disputes arising from surrogacy situations and agreements from as far back as 2014. And I'll quote some of the judges and what they've said regarding Kenya's lack of a regulatory framework. So Justice Lenaula in JLN and two others versus Director of Children's Services had this to say that currently there is no law in Kenya regulating surrogacy arrangements. It is because of lack of a legal regime that the parties found themselves in such a situation. He went on to speak to the realities that surrogacy is not a hypothetical issue anymore. It is real, and many Kenyans are resorting to surrogacy as an alternative to being parents, especially those who cannot, for medical reasons, have their own children. In such circumstances, it is the duty of the state to protect children born out of such arrangements by providing a legal framework to govern such arrangements. So the court in that instance actually called for government to pass a legal framework that would regulate surrogacy in the country. Just last year, Justice Kendagor, just speaking on surrogacy agreements as well, mentioned that they were relatively new within the Kenyan legal system. And however, the arrangements were gaining traction, and Kenyan courts had the obligation to address the issues that arose from the same. So the Assisted Reproductive Technologies Bill that we'll be discussing was passed by the National Assembly in November of last year, and it's currently before the Senate, which is another house of our parliament. The objects of the law under Clause 4 are to provide a framework for assisted reproductive technologies services for every person, to create an enabling environment for the reduction of infertility and subfertility in Kenya, ensure access to quality and comprehensive assisted reproductive technology in line with Article 43(1) of the Constitution, and ensure the best interest of children, and facilitate the registration of children born out of gestational surrogacy arrangements, as well as promote research into the incidence, causes, and prevention of infertility, and provide a framework for surrogacy arrangements, permit altruistic surrogacy, and, as is the case in the UK, prohibit commercial surrogacy, and establish an assisted reproductive technology committee. So in terms of what the bill proposes in terms of regulation, under Clause 5, KMPDC, which is the Kenya Medical Practitioners and Dentists Council, is to establish an assisted reproductive technology committee. However, in terms of the functions, this is taken back to KMPDC. So reading of this would be that the ART committee would just be a committee of KMPDC and not independent when you read the bill. And in terms of regulation then, KMPDC or the council will develop standards and regulations and guidelines on assisted reproductive technologies, promote research on the conduct, control, and treatment of ART, develop programs for awareness creation on methods of ART, regulate the facilities and experts that offer ART by granting, suspending, and revoking licenses, and also maintain and make public a register of all licensed ART facilities and experts. It has other functions as well that I won't speak to in the presentation. Then there are also obligations that are placed on the government. Kenya has a devolved structure of government with a national government and 47 county governments. So for the national government, under Clause 7, the Cabinet Secretary is to put in place mechanisms and infrastructure and provide adequate resources to ensure access to the highest attainable standard and quality of cost-effective ART services. I think Rose spoke to the prohibitive costs that actually bar a majority of people who desire to access ART from actually accessing these services. So the CS is obligated to ensure that there's infrastructure in place and the adequate resources that would enable access to cost-effective ART services. And then the CS is also to provide regulations to ensure assisted reproductive health services are covered by every health insurance provider, including SHA, which is the Social Health Authority. And this also speaks to the cost, trying to address the issues in terms of the prohibitive cost in access to assisted reproduction. And then the CS is also to collaborate with county governments to expand and strengthen access and delivery of assisted reproductive health services in counties. For county governments, under Clause 8, they are to allocate in the county budget funds necessary for the provision of quality, cost-effective ART services in the county health system, and to procure equipment, medicine, and medical supplies required to cater for assisted reproduction health care services in their respective counties, and also to carry out sensitization programs on ART and mobilize and source for funding of ART from local and international development partners. They are to also allocate in the... Okay, yeah. So this speaks to the obligations of states to ensure scientific benefits are physically available and economically affordable on an undiscriminatory basis. Then who qualifies for surrogacy? Under Clause 22.1, every person has a right to access the highest standards and quality of attainable and cost-effective ART services. The bill, however, provides some criteria on who, would qualify for access. So one, there's need for an ART expert to satisfy that a person requires ART on medical or health grounds. And then for the intended parent, woman or couple that enters into a surrogacy agreement, in terms of who can access. So Rose spoke of married couples, and Tom also, Dr. Msil also spoke to that it's married couples only who can access. So in Kenya currently, under the draft law, what the law seeks is for intended parents to either be a couple, they can be married or not, or a single woman. So single men seem to be excluded in this, and for that, there's need to ask the question on single men's right to private and family life, including the right to decide whether or not to become parents, and also the issue of discrimination, non-discrimination on the basis of gender for men desiring to be intended parents. And then in terms of an intended parent, they must be a Kenyan. So this speaks to foreigners, it bars foreigners because it only speaks to intended parents being Kenyans, and places an age limit, Kenyans between the age of 25 to 55 years. And then for surrogates, so surrogates must be aged 25 to 44 years. They should have given birth at least once, and must undergo comprehensive mental and physical assessment, and they must understand the rights and obligations accruing under the surrogacy agreement. We'll come back to this later. And then a surrogate cannot enter into a surrogacy agreement more than 3 times in their lifetime, and they must wait 2 years between each birth to be eligible for another surrogacy agreement. So what are the rights of the surrogate under the bill? So the bill speaks to surrogates being entitled to 3 months local leave. This is under Clause 29, subclause 1. Looking at this, there may be need to align the Employment Act with this provision, because the Employment Act only speaks of maternity leave, sick leave, and adoption. So there's no mention of local leave, which then would mean the Employment Act would need to be aligned to ensure that surrogates have can access this leave. And then surrogates also have the right to insurance cover, and the policy should start on the day that the first AR procedure is undertaken until 5 years after birth. Then they also have a right to separate and independent legal representation while entering the surrogacy agreement, and to psychological support during and after the pregnancy. For the legal and psychological support, this is to be offered at the cost of the intending parents. The rights of children born out of ART, so they have the same legal rights under the Constitution and other written law as children born through natural conception. This is under clause 25(1). They are protected from abandonment by intending parents under clause 34(8). And the bill also further criminalizes the abandonment of children born out of ART or surrogacy. Then they are also protected even in cases where the child has congenital abnormalities. I think we've seen cases where intending parents, after the child is born, and they realize that the children either have congenital abnormality, including, for example, Down syndrome, then in some instances there's been abandonment of the child born out of the surrogacy agreement. So this seeks to protect children who may be born with congenital abnormalities. And then upon attaining the age of 18, children born out of surrogacy agreements may request for information from the council on whether the applicant, now them, the children, were conceived through assisted reproduction, and whether the information in the AR register shows that a person the applicant includes in the application and they propose to marry would or might be a relative. So the law is progressive, as colleagues have already spoken on, and it's also progressive compared to previous versions of the law that were before the National Assembly, especially before it went to committee stage. But there are still some gaps in it, and I'll speak to some of them. For example, under clause 2, it still speaks to a surrogate mother, yet the intention is not for the surrogate to be a mother in any form. So we'd recommend the use of a person acting as surrogate as compared to the use of a surrogate mother. And then in terms of application to court for necessary orders, what the bill currently provides is for application to court for orders for the validity of a surrogacy agreement, a dispute relating to parentage of a child as a result of an assisted reproduction procedure. The law may also include the enforcement of any provisions of the surrogacy agreement. Then clause 27(3) provides that where the surrogate mother or intended parents has no genetic connection with the child, the surrogate mother shall, subject to a court order, relinquish all parental rights and responsibilities at birth over the child to the intended parents. Yet clause 27(2) speaks to a surrogate mother relinquishing all parental rights at birth automatically. So there's a bit of contradiction under 27(3) and 27(2), which, if there's mischief that seeks to be sought, could be addressed under clause under the surrogacy agreement. The clause 34(1) also makes a distinction in terms of genetic connection. So there seems to be a difference in how the draft law deals with children born where there's no genetic connection with the surrogate mother or intended parents, and where there's a genetic connection with the intended parents. Thank you, Prudence. Back to you.
Yeah, thanks so much, Wanjiru, for that intervention and the great submissions. I would say well done. And before I let you go, and I know that I don't think Professor Julia has managed to join us. So we'll be moving to the Q&A session. Wanjiru, you've listened to what Rose presented around some of the antepartum detentions, happening to surrogates in Uganda. And I know that the Center for Reproductive Rights has had a chance to litigate, for example, here in Kenya, in Civil Appeal number 61 of 2018, the Josephine Majani case, as well as Petition 562 of 2012, decided by Justice Mumbi Ngoge in 2016 around postpartum detention. What are some of the lessons that we can draw from those two particular cases and, apply them to the protection of surrogate mothers, as has been seen in the case of Uganda?
Mhm. Thank you, Prudence. So the courts in Kenya, including the Court of Appeal sitting in Kisumu, over the matter we refer to as the Bungoma matter, have spoken on the right to respectful maternity care for women and girls who present to health facilities seeking maternal health services. We've had situations where women who present to health services are detained for one reason or the other, in most instances for failure to pay maternity fees. We've seen also in Uganda, similarly, detention of mothers for failure to pay post-delivery. So the court speaks to minimum co-obligations of states of the Kenyan government, including county governments, to ensure that there's respectful maternity care to mothers. The court in Nairobi on the Pumwani matter spoke to detention post-delivery being a violation of women's constitutional rights. And the court in Bungoma also spoke to the use of physical abuse, verbal abuse being a violation of the maternal health and constitutional right of women. And this definitely would also offer protection to surrogates who present to health facilities as well to deliver. Given the learnings from Kenya, the center is also currently working to support the Africa Commission on Human and People's Rights to develop guidelines on respectful maternal health care, and that also seek to address obstetric violence within the continent. And given the conversations we're having today, there may be need for this to also reflect in the guidelines in situations where the women who are presenting to deliver are actually surrogate mother, and also given what Rose spoke of, what Gemma spoke of, at times in terms of violation of surrogate mothers. So there may be need actually to have that reflected in the guidelines that the Commission is currently developing. Thank you, Prudence.
Wonderful. Thank you so much, Wanjiru, for that great submission and intervention as well. And so, colleagues, we move to the Q&A session. I know there are a couple of hands. I think I've seen, let me see. Gabriel, I think I saw two hands, one from Enrica Dulo, and I can't see the other hand. And I don't know from your end, Gabriel, whether you would want us to give them an opportunity to make their intervention and ask the question. But at the same time, we also have questions in the chat. And as Gabriel comes in to respond to that, I can just quickly go through the questions and allocate them in the order of presentation, starting with Tom, then Rose, then Gemma, then Wanjiru. I'm informed that Professor has been unable to join because of internet challenges, and so hopefully for around two of these, she'll have an opportunity to join. So there is an anonymous attendee who has, I would believe this is a two-part question. Number one is on constitutional and human rights lens. How should courts in African jurisdictions balance the right to found a family against competing concerns such as public morality and child protection in surrogacy arrangements? And to what extent Does the constitutional right to human dignity and autonomy extend to individuals seeking ART, including single persons and LGBTQ plus individuals? Then there's a question around, can restrictions of surrogacy be challenged as unconstitutional discrimination, and what threshold should courts apply? So Dr. Tom, you can take that question around the constitutional and human rights lens. Then Rose, there's a question around legal parenthood and status of the child. So the question is, in the absence of clear statutes, how should courts determine legal parenthood? So the genetic link, gestational role, or intention. And I know Gemma, sort of answered, that particular question in our presentation. What legal safeguards should be put in place to ensure that children born through ART are not rendered stateless or parentless? Should African jurisdictions adopt a uniform rule, recognize intended parents at birth, and what risks might this pose? So I'll be requesting Rose and Gemma to react to that particular question. Then there's a question around data protection and genetic information. Who owns and controls genetic materials, that's gametes and embryos, under African law? How should jurisdictions regulate access to donor identity information, especially as children grow older? What safeguards are needed to protect genetic privacy and prevent misuse of data? So Tom, I will also be asking you to respond to that, given the law in Uganda. And Wanjiru, perhaps you can also come in, because I know the ART bill also, provides something around this. And Gemma, it also be great to learn from you how the UK continues to address the issue of data protection and genetic information. Then I think this is a repetition by Wycliffe Ango around the legal parenthood and status of the child, because it's around the question of the genetic link, stateless or parentless. There's a question here, because I don't want to miss the regulatory gaps and policy design. So given the fragmented legal landscape across Africa, is it more appropriate to pursue comprehensive legislation or incremental judicial development? What minimum regulatory standards should apply to fertility clinics to prevent exploitation and malpractice? Should there be a central regulatory authority for ART, and what powers should it have? There's a question around commercial and altruistic surrogacy, and thank you, Wycliffe, for these excellent questions, because they shaped our discussion. Should African countries permit commercial surrogacy, or does it inherently risk commodification of women and children if commercial surrogacy? Okay, the question is not complete, but we do get the question around commercial surrogacy and the commodification of women and children. And so Rose and Wanjiru and Dr. Tom, you can answer that as well as Gemma, if you have some time. There's a question again around what is the view on IVF? Has any practitioner dealt with private family law trusts and the consideration of including children born through ART as family members and therefore beneficiaries of the trust? Gemma, perhaps you can take that question. So that was posted in the Q&A. There's a question that I had seen, I don't know whether this was in the chat, from Miss Beryl Kopere. And it was around, or it's been answered. Let me see. So yes, so Beryl had asked, and these I will throw both to Gemma and Dr. Mulisa. So Beryl says, thank you for the enlightening presentations. In a case where the commission or intended parents are from the UK and the surrogate mother is Rwandese, if the child is born in Rwanda and the birth certificate is issued, is the child considered Rwandese by nationality? In addition, if the intended parents process the child's passport for travel back to the UK by virtue of being named in the birth certificate, get consent of the surrogate mother, and consequently get a parental order from the UK court, does this child hold a dual citizenship of Rwanda and UK. And I think Dr. Tom and Gemma, you can both answer that. So we can just go in the order of presentations. We start with you, Tom, then Rose, then we'll have Gemma, then Wanjiro, and then we'll come back and see whether there are any other questions we can, answer from the chat. Gabriel, you can guide me on whether we will give an opportunity to the colleagues who raise their hands to make the interventions as well. Over to you, Dr. Tom.
Yes, thank you very much. And I think I'm first dealing with the question from the anonymous attendee. Then I will see through if I get to the other question, especially the issue of nationality. The anonymous attendee asks, how should courts in African jurisdictions balance the right to found a family against competing concerns such as public morality and child protection in the surrogacy arrangements? I think, as you've seen, jurisprudence around assisted reproduction, we don't have much jurisprudence around that. You've seen the case we had in Rwanda, and you've seen the case Wanjiru has quoted the Kenyan case. I think it's a new emerging, I mean, within the African jurisprudence in terms of litigation. But as we've been discussing around rights, since there are issues relating to the rights of the child, since there are issues relating to the rights of the family, and issues relating to the rights of women, and Wanjiru talks about also men surrogates. So I think since there are issues relating to the family, this I think is an issue that could be litigated also within our jurisdictions. So if we are talking about a family, of people that need a child and have been limited by the law, if we have a couple that needs a child, but the law is a limitation, I think that family could, based on the very values and rights provided under the Constitution and under the other laws in the country, to seek constitutional adjudication. The Rwandan law, going back to Rwanda itself, because I think I got an opportunity of meeting the team that was working on the draft law. We had a sexual reproductive health law, and then we had a medical liability law. So looking at the two laws and looking at the family law in Rwanda, I got an opportunity, I think, also to engage the Parliamentary Committee on Social Affairs that amended the bill that had been submitted by the Minister of Health. What was central in the Rwandan law of 2025 was not only protection of the surrogate, but also protection of the child. So the parliamentarians in Rwanda have said that the child born out of this process is no different from the ordinary child protected under the Rwandan law. So we are not talking about two legal regimes for protecting of children. The law that protects the child in Rwanda is the very law that is going to protect the child born through the process of assisted reproduction. So there's no specific regime for child protection for children born under this assisted reproduction technology from the child born in the natural process. So the law protecting the child will apply to all. I think that became very clear with the parliamentary notes and the law and the recent law in Rwanda. So it means that the child will be protected through all that. Can restrictions on surrogacy be challenged as an unconstitutional limitation? I think yes. If there are people that are not legally married, yet the law talks about, let me take on the Rwandan law that says that you can only enter contract in case you are married. What happens to a single person who does not intend to marry but intends to have a family and have a child? So I think that looking at the laws that we have in place, I think that there are prima facie grounds for people who are not legally married but have even children but are not legally married, because in Rwanda legal marriage is provided for by the law, but we have people in cohabitation who have children. Can they go in again and raise children through assisted reproduction, since they already have even children? So I think that these very grounds, the limitations the law provides for like only those in marriage, can always be challenged in court, and I think there are prima facie grounds for such a challenge. In the absence of clear statutes, how should courts determine legal parenthood, genetic link, gestation role, and intention? I think, first of all, there is a contract. We are talking about people entering a contract. And I think the Rwandan law, the ministerial order that we are waiting for, is to draw lines on the nature of contract and the minimum content of that contract, yeah, between the intending parents and the surrogate. So I think, just as usual, genetic proof is provided in case of disputes, I think it will follow the same suit. What legal safeguards should be put in place to ensure that children through ART are not rendered stateless or parentless? I think this is an important question, and I think legislators, while looking at assisted reproductive technology laws, should look into this. For the case of Rwanda, the law has been very clear that the law on nationality. We have a law on nationality, and this law borrows from the family law. So if a child is born in Rwanda with the Rwandan parents, the law that follows suit that child is going to be Rwandan. Born in Rwanda, the law on nationality, which follows the family law. The child born in Rwanda or the child born to Rwandan to a Rwandan family child. And in Rwanda, the law is very clear that the law allows. I think that will respond to the other question, that the Rwandan laws allows double nationality, different perhaps from other countries or someone being born elsewhere. So what legal safeguards should be put in place to ensure that children born are not rendered stateless? I think the law protecting children in that particular country should protect children regardless whether they have been born, it's a natural birth, or they have been born through assisted reproductive technology. That one remains a child. That one, I mean, using the Rwandan lens of interpretation by the parliamentary committee in Rwanda. Should African jurisprudence adopt a uniform rule recognizing intended parents at birth, and what risk should this pose? I think the challenge, first of all, the challenge that we have in the African settings is that we have not had enough developed jurisprudence, I mean, within the East African context here, because you can imagine the first case in Rwanda was that of 2020, and that's the only case. We have not yet had such other disputes calling for litigation right now, but I think jurisdiction should come in place, not only to protect the child, but also to protect also the intending parents and the surrogates. So that's what we should be looking at the law. But one of our parliamentarians in Rwanda was saying, what is the problem? You have the law that protects the child. So a child born naturally and the child born through assisted reproductive are all children that all need protection. Why should you look at whether the child is natural or born through assisted reproduction? The child should be protected as a child. We shouldn't create any other legal framework that is quite different from that one that protects the child. So, and I think this goes to the other question where someone asked whether the child can have double nationality. That will all depend on the legislation within the country. And for private international law application in each country will always depend on the legislation of that particular country on issues of nationality and marriage. The national legislative framework for nationality and marriage within our own states under private international law will always regulate issues of conflict, children, and adoption, the same as it does for children born naturally, will always apply also to children born by ART. So if commercial surrogacy is prohibited, I think in most of our jurisdiction, commercial surrogacy is prohibited. And this one is intended to avoid exploitation of the surrogate. It's prohibited, and I'm not very sure, because some questions were long, whether you can remind me of some other thing that I should talk about.
All right. Thanks, Tom, for that intervention. Perhaps we can move on to Rose at this moment. Perhaps, Rose, you can take the question around data protection and genetic information, and I'll see Dr. Tom if there's a question that will need your intervention as Rose makes the intervention. Perhaps, Rose, you can do that in about 3 minutes so that we move on to the other panelists as well.
Thank you so much. So for some of the questions maybe that were addressed to me before, I try and answer the one around data protection. Around the status of a child, for Uganda, the person, according to our Registration of Births and Deaths Act, the person proof of proof of proof of registration is by way of birth certificate. So the people on the birth certificate are the ones who are considered the parents. So often they will use this birth certificate to secure a visa, or they will use it to secure a passport for the child, and the child will go. Uh, for for us now to access services, as long as your parents are Ugandan, the commissioning parents, and they are listed in the birth certificate, then they are the ones who take on the parental rights. So our Children's Act, similarly as with Rwanda, will automatically protect these children, and every child must have a birth certificate with listed parents. So in that way, not very, it's not easy to leave a child stateless. They are already protected with the existing laws that we have. There are many concerns around ethical considerations. Ethical considerations always wonder from where you are situated. And people always talk about whether it is ethical to have children who are not naturally conceived through sex, and these are some of the pushbacks that we have had towards assisted reproductive technologies. For us, we always try to interpret art through the lens of reproductive justice. And when you're actually concretely looking at the human rights of human beings, there is the right to produce, the right not to produce, and the right to raise your children. So when you're looking at the right to produce, you're majorly concerned about people being able to have children and look after them and love on them and groom them to be good citizens for the world. How these children are conceived is not really, for one person, it may be easy to conceive the child through sex. For others, it may be technically impossible for them to do it naturally. So they may need a little extra help. So it's just about not imposing your own way of life or your own way of thinking on other people and closing them out of certain spaces like parenthood, and allowing everyone to experience certain ways of life. Around commercial and altruistic surrogacy, someone asked, is it a business? The short of it is yes, it is a business, especially for the health workers. They earn. What some of our richest doctors in Uganda are people who are providing assisted reproductive technologies. But when you look at the cake, the question is, how is it apportioned? Who is getting the big share or the chunk of it, and who is being disenfranchised within it? I don't think we can take money out of assisted reproductive technologies. Unfortunately, we live in a capitalistic world, so everything is valued around money and the exchange of money. And as I had already talked about, most of these people who offer services as surrogates are people who are looking at, at this as an opportunity to get out of poverty, as an opportunity to get money that they probably would never get, even if they worked for the entirety of their lives, and to improve their economic status. So when you adopt an altruistic model for surrogacy, and this is something that was done, I think, in India, they put it in their law that it's going to be altruistic. I think also Rwanda did altruistic. The proposed bill of Kenya is also around altruistic, but it's not being realistic to the reason as to why women actually offer themselves as surrogates. I don't know why people keep thinking that women, we are naturally kind-hearted, we never think about money, we just want to, we are nice. No, people enter surrogacy in order to earn a living. And it's just about making sure that there are guardrails, that there is value for money. People must be compensated for lost time. They must be compensated for loss of wages. They must be compensated for, like, there has to be value for money. You can't just say, oh, your body is going to change for these 9 months. All these things are going to happen to you. Your moods will change, but you're not going to earn anything out of it. I feel that is a little bit unfair. And, there is a concept that is now being put forward around reproductive labor and attaching value to the reproductive roles that women now play in our society. So I don't think the altruistic model for regulating around surrogacy is something that is sustainable, especially in contexts where there is a lot of poverty, like in Uganda, because this is just going to even further encourage a lot of abuse and exploitation, because now people are going to do it underhand, and then it's just going to become a mess, because now you cannot enforce a contract or enforce for your wages or for the pay that is due to you, because the law does not allow it. And yet, most of the time, at the back end, it would have been promised. So women are just going to be further exploited by that model. I also wanted to mention that there have been attempts to address surrogacy regionally in the East Africa Community SRH bill that had been proposed, I think, in 2021. And there are things that had been put there to try and get ahead of this issue and have a law that regulates us regionally. So I think this is also a good opportunity for us to have some sort of legislation that will cover all the 7 East African countries. And around adoption, there is someone who had asked, can a surrogate mother sign an adoption? Yes, because the requirement in our context in Uganda is that if there are living parents for a child and you want to procure an adoption, then they must consent to the adoption, or you must demonstrate that the parents cannot be found or cannot be seen, or that they are dead. But how people are overcoming this is by putting the commissioning parent directly on the birth certificate. So ultimately, you're supposed to apply for adoption, but people don't do it. They just put them on the birth certificate, and then the child just legally becomes yours by jumping that criteria. Because also adoption takes a very long time. It takes about 3 years to conclude. Many people will also opt for the option of applying for guardianship, but that also takes about a year, which is very long. Yeah, so I don't know what else I haven't answered, but I'll stop there. I feel like I've overtook.
Yeah, thank you so much, Rose. I wanted to give the opportunity to Enrica to make an intervention maybe in 1 minute so that I can have Gemma and Wanjiru come in and react to any question that Enrica might have. I know she's an advocate of the High Court of Kenya who's worked on these issues. Enrica, please make your intervention brief.
Hi, Prudence. Good afternoon, everyone. Thank you very much. Allow me to have my video turned off. Thank you all to your presenters. Now, especially to the speakers from Kenya and Uganda and Rwanda, because of the region, I think it's key that we make the child the center. So we should look at the laws we are developing in our respective jurisdictions more from a child rights lens. I know CRR may argue with me on this, but because the product of a successful embryo transfer in ART is a child. So how are we protecting that child? If you look at the World Human Trafficking Report, Kenya is on Tier 2 watch list, which we've been on for over 10 years. I looked at the report, the last one published, I think 2023, 2024. Uganda, you're on Tier 2. So you're doing better than us. Therefore, any proposed law, any bill that is proposing that we do a direct transfer, I think if it passes Parliament and it becomes law, then the next big criminal aspect whichever country has passed that will start dealing with will be on trafficking, because you need to protect the child. But if you want to do direct transfer, not everyone will be interested in doing a direct transfer of a child born through a surrogate. You will have people who have their own agenda, and they will claim that this was a surrogacy agreement, and then they do a direct transfer. So any bill that we are proposing, one of the provisions should be, there should be a court process. And then also, as practitioners, if you do direct transfer, you are actually shrinking the space for legal practitioners. So topmost, let's protect the children. But let's simplify it. Adoption is not necessary. If you look at the process in the UK, adoption is only an alternate process if you didn't approach court within the first 6 months. Yeah, after that is when now you have to do an adoption. But below that, from 6 weeks, when the surrogate is allowed to give consent, from 6 weeks to 6 and below 6 months, you don't need to go through adoption. Then I know there's a debate, especially on Western countries, that it has to be completely altruistic. But their economic situation is different from ours. I know one of the arguments that our parliamentarians in Kenya have put forth for banning international surrogacy is that if you ban international surrogacy, you're going to ban commercialization. I don't know which practitioner they consulted or which former surrogate they consulted on that, because that is absolutely wrong. Whoever gave that proposal misled them. Any woman, when I do legal consultation, the first thing I ask them, why are you offering yourself? And they tell you they need the money. They want the money to start business. They want the money to change their life. They have a child who is due to join university. So in Africa, let us not, or in the region, we need to stop the lie that we cannot do commercial. Probably what we need now to do is to regulate it so that the surrogates are protected from exploitation.
Yes.
And then also we don't make it so exorbitant that the IPs cannot afford it.
Yeah. Right.
But the surrogates in our region, they sign up because of the money factor.
Yeah.
So without much further ado, thank you very much, Prudence, and everyone else. Lovely seeing you online. But
Thank
make
you.
children the central focus.
Yes,
Thank you.
Enrica, we've had you. Thank you so much. I would want to give the opportunity to Gemma to make her submissions and reactions as well, and then we'll close with Wanjiro in the next few minutes. Gemma?
Yeah, I'm obviously really conscious of the time, and also that this is directed to, I'm very happy to pass over to my colleagues in Kenya, Uganda and Rwanda to answer questions. But I just want to say I very much agree that making the child the centre of developing laws has got to be the key. And, you know, there's got to be proper practices and procedures in place. And the only way that we can do this, as I said before, is if we can talk together and share. We've got to look at ways to regulate things. We've got to find the right times for information to be shared with the right people, because, you know, lots of things are happening from the wrong way from the UK perspective. You know, everything's sort of happening at the end of the process rather than the beginning of the process. It's back to front, and we need to work out a way of getting that information, you know, to the front, so that we're not putting families in positions where they are giving, you know, the children are being born who are stateless and who are parentless. You know, it's just something that cannot continue. So very happy, conscious of the time, it's 2 o'clock, to pass over to Wanjiro.
Yeah. Thank you so much. Wanjiro, any last remark?
Yeah, thank you, Prudence. The question on adoption that I think colleagues spoke to, but maybe just to say, in the lacuna of lack of a proper law on assisted reproduction, the courts have actually been relying on adoption processes where intending parents are conferred parental rights, like through an adoption process, even when the children born out of the surrogacy are genetically theirs. However, then, should Kenya pass the ART bill as is, the surrogate's role ends, you know, like, because she would relinquish her parental rights at birth automatically. So then she would not have a role to play in terms of like an adoption process that would happen. There was also the question around access to information, and maybe I'd ask colleagues, I think we'll share a link to the ART bill in Kenya and just see how it addresses this under clause 38, where it speaks to the council maintaining an ART register. And also how it seeks to balance this information with the right to confidentiality and the right to privacy of the parties involved in a surrogacy kind of arrangement. There was a concern by one of the I think Wilfred, one of the participants, regarding the denial of single men to be intending parents. And that, as I mentioned, would be a question for practitioners, lawyers to question on the non-discrimination, the right to non-discrimination for men as well. And then Enrica spoke to trafficking. And I mean, as she spoke and as we were reading this and discussing internally as a center, there was also the thinking around why the limitation of intending parents to only Kenyans. And we actually thought that could be one way that Parliament is seeking to address the mischief or the challenge that trafficking would also arise from surrogacy agreements. And also perhaps the clause that I spoke to, 27.3, that speaks of a court process upon the birth of a child who is not genetically linked to either the intending parents or to the surrogate mother. This as well could also be just a way to ensure that the courts, the country, the regulatory framework is actually addressing concerns around trafficking of the child. And we agree the rights of all the parties in a surrogacy or ART arrangement really need to be upheld, from the child that's born from this process, from the surrogate, from the intending parents as well. So we agree with Enrica on that as well. Thank you so much, Prudence, and to colleagues as well.
Thank you so much. And colleagues, I believe we've come to the end of our session. Please, we beg your pardon if we've not been able to respond to some of the queries that you've raised or some of the comments, or given you an opportunity to intervene. And we believe with the East Africa Law Society, we'll have another opportunity to engage further on this particular emerging and timely issue. And we've heard from Dr. Tom Mulisa on the situation in Rwanda. We've heard from our feminist scholar, Ms. Rose Wachikona, on the situation in Uganda. We've heard from Ms. Gemma Dali on what the practice is in the United Kingdom. And of course, with Wanjiru, the pitfalls and the successes around the AR bill and what the Center for Reproductive Rights has advocated around protection of surrogate mothers, and of course the intervention from Enrica around having a child rights centered approach as well when it comes to AR. And thank you so much, colleagues, for all your great questions, interventions, and having stayed with us for the last 2 hours. I want to send a special shout out to the East Africa Law Society for having hosted us and, supported us in the prepping for this particular session, and the East Africa Law Society Family Committee. A special thanks to the chairperson, Ms. Patricia Mundia, for organizing these, and to the International Academy of Family Lawyers as well, including Ms. Gemma Dali and Rika Dulo, for having supported us to host this session, and of course to the Center for Reproductive Rights for having given us an opportunity to also intervene, and to our great panelists, Dr. Tom Mulisa, Ms. Rose Wachikona, Ms. Gemma Dali, and Ms. Wanjiru Kamanda. Thank you so much for your great insights and for the wonderful, wonderful submissions. I believe we have learned a great deal as East Africa Law Society on what AR is about and some of the legal and ethical concerns that we have emerging. And Gabriel Asaya, over to you. Gabriel, are you online with us? Okay. So if Gabriel is not online with us,
Prudence, good afternoon.
Yes. Good afternoon.
Yes, sorry, I was online and I thought for a moment I had unmuted, but unfortunately I was on mute.
Oh, okay.
Yes.
Okay. I wanted to hand it over to you now.
Yes. So Prudence and our dear esteemed panelists, it's been quite an incredible journey with you all from the hour of 2 until now that we have over 240 participants present at the call. Shows just how important this conversation is for us to be having at this juncture. And on behalf of the East Africa Law Society, we would like to thank you all for taking time to prepare for this session. To our participants on Zoom and on YouTube, would like to send a big thank you to you as well for always making time and joining through our webinar sessions that we conduct weekly. Our esteemed partners from IFL, CRR, Prudence, and the entire team, thank you so much for organizing and coordinating this very wonderful webinar session that we've had this afternoon. We look forward to having a more detailed conversation around this area or more engagements as we build our capacities. A recording of this session will be shared with you all members, and please be on the lookout. We are on your emails and the different platforms. Otherwise, from us to you, it's a very lovely afternoon to you. We wish you all a very blessed week ahead. And as we close into the weekend, please enjoy your weekend. As we log off, please allow me to also remind you that our AI Masterclass for Lawyers is coming to Nairobi, the capital city of Kenya. That will be from the 7th to the 8th of May. If you have not yet reserved your slot, please reserve your slot. Visit us at info@elawsociety.org or visit our website at www.elawsociety. The AI Masterclass is an opportunity for you to learn hands-on on how you can use AI to simplify your day-to-day tasks, but also to make you more efficient and effective as you serve your clients. So please, you do not want to miss that. It's going to be a practical session, highly interactive, and we look forward to hosting you all in Nairobi. Next week, we'll be having another session that will be discussing intellectual property and sports law as we commemorate the Intellectual Property Day that is today. Otherwise, we thank you all and wish you all a very lovely evening ahead. Goodbye, and until we meet again next Tuesday. Bye.
Thank you. Bye.
Bye.
Bye-bye.